Ben will take us through the ruling and provide commentary. Then the parents are going to give their individual statements and comments, with Ven, I believe, reading a statement from Justin Schilling's father, Craig Schilling, who is not able to be present today. We'll then take questions, first from those in the room with us, and then we'll ask that those joining us virtually please put your questions in the Zoom Q&A section, and then specify to whom the question is directed. Ben, go ahead and take it.
Thank you. Good morning. You all know why we're here, and we appreciate that you're here to hear from our clients after last Friday's ruling by Judge Brennan in the Oakland County Circuit Court, dismissing all claims because of governmental immunity against all the Oxford Community School employees, as well as the Oxford Community School itself. I want to introduce everybody to make sure, even though I know we have name tags, that you know who everybody is. On my far right, Jill Soave, here on behalf of her son, Justin Schilling. As Justin said, Craig Schilling is attending today by way of Zoom, but unfortunately, because of some technical glitches, he was not able to be interactive with us today. For that, Craig, I apologize to you. And Craig has asked me to read his statement on his behalf, so I will do that at the appropriate time. Moving over toward me on my right, Meghan Gregory. Chad Gregory is unfortunately not able to be with us today. That's mom and dad of Keegan Gregory. Chris Desmond is our chief appellate lawyer at Johnson Law. In addition to being that, Chris formerly worked for the Michigan Court of Appeals as a research attorney, and therefore has some incredibly important insight about what our appeal will be like, the general time frame, and I'll call it certain appellate issues. So if anybody wants to get in the weeds on that, obviously I'm going to defer to the expert, Chris Desmond. On my left, Ken Khahra is also my co-counsel in this case from Johnson Law. To his left, Buck Myre on behalf of Tate Myre, and of course, Sherri Myre on Buck's left on behalf of Tate Myre. We also have other clients, folks. Two people couldn't make it because of schedule, one because of sickness, so I just want to give a shout out to Lauren Aliano and Laura Lucas. You all are here with us. Okay, let's talk about Judge Brennan's ruling. And first and foremost, before I actually put up on the board the opinion in order, I want to make abundantly clear. I've known Judge Brennan for years. She's a highly respected jurist. And nothing that any one of us say today are we meaning any disrespect for the court whatsoever. Obviously, we feel very strongly about the facts and circumstances of this case and how it should be proceeding to trial. So we respectfully disagree with some of Judge's findings, but what it really illustrates, number one and foremost, on behalf of everybody before you, is the inherent unfairness, I'm using a nice word, crookedness, if you will, evility, if you will, of governmental immunity, a system that was designed to protect the government and its employees from being held liable in a civil courtroom like everybody else across the country, whether they're corporate defendants, individual defendants that work for a corporation, rich, poor, private, no matter what, everybody in this day and age, 2023, in a courtroom in the United States should be equal. No one should have greater footing than anybody else. And for a government to pass laws to protect itself from being held accountable when in a situation like this, overwhelmingly, they were absolutely wrong, we think is unconstitutional, and we'll explain why in a minute. So, let's start, if we can, with a little bit about governmental immunity, and I've asked Chris to talk, Desmond, about it as well from his perspective. Historically, common law means law basically brought over with us, from some of us, from England. Not just Michigan, I may add. Not every state has it, but I would say most states have it, but most states don't do what we do to make it so difficult that you can't sue your government, but that's another day. Back in the day, so when we first got here and the United States was first colonizing and then ultimately became the United States in 1776, from then until 1961 here in Michigan, I'm talking about Michigan law now, you could not sue your government. Same concept. King says no. In 1961, in a 5-4 Michigan Supreme Court decision, Justice Black was a justice, he was an innovator, he was an independent thinker, and parenthetically, Amelia Black, one of our co-counsels who's here today, it's her grandfather. Interesting, ironically enough. Justice Black ruled in 1961, this isn't England, and we're not in the 17 and 1800s. In this day and age, school districts, governments, they're more like corporations and businesses. They all have insurance. We have an inherent risks in all the things that we do. So it's not fair here in Michigan when the government employees hurt somebody through their negligence. It's not fair that we don't allow them to sue in a civil court. So 5-4, 1961, Justice Black, thank you, therefore ruled, and the Michigan Supreme Court ruled, you could sue, not your government, to be fair, but you could sue governmental employees for negligence and a proximate cause. Real quick, what's proximate cause? A relationship between negligence and injury. That's it. Someone runs through a red light. They're texting instead of driving, and they run through a red light and hurt me. I sue them. You were negligent when you didn't pay attention to the red light, and you broke my leg. Negligence caused my broken leg in the car accident. That is civil law in Michigan, folks, plain and simple, and we do it every day, no matter who is the person that's wrong, except for governmental immunity. So in 1961 until 1986, you could sue governmental employees in Michigan for negligence as long as there was a proximate relationship between the injury and the negligence and the injury. In 1986, thank you, Chris Desmond, the Government Tort Liability Act, GTLA, was passed by who? The Michigan legislature. Why? Because they didn't like being held responsible for them and their employees injuring Michigan citizens. So they created this new law that said a number of things. Still, you can't sue an entity, a state entity, or not just a state entity, but a governmental entity, unless there's 6 exceptions. I'll explain that in a minute, or maybe Chris will. Most of the time, those exceptions never apply, by the way. So, for these 6 reasons, you can sue the government. But on every other thing that happens outside of those 6, which is the overwhelming majority of all of them, you have to sue the government employees. Now, I ask you, who would want, as an employer or the runner of a big organization, who would want their employee to be sued instead of the corporation? At Johnson Law, God forbid, if one of my employees did something wrong and hurt somebody, I wouldn't want them to put through the ringer. My insurance company is going to come in and represent them, represent my law firm, and then take care of the whole matter. That's what insurance is for. Except in governmental immunity, they actually tell us we have to sue the individual employee. So for those of you out there who are critical of me and us for suing teachers and administrators in a school district, your answer is the law requires us to do so. So it encourages us to sue individuals, and in this case, of course, we had multiple from the school district, 3, 4, 5, 6, 7. 7 school district employees, whereas if it were a corporation, by the way, I would just sue the corporation and say, you're responsible for these 7 people and what they do, and not even sue those individuals likely. So the law requires me to sue.
Vin, can
Yes.
I hop in real quick? And this is the propaganda that the teachers and the school employees are being fed, that we are against them.
And we're not.
Correct. Sorry.
Yes, sir. So, now we get to the gross negligence of the proximate cause. I will tell you, in 37 years of practice, Chris, if I'm wrong, please tell the folks, I have never seen another state have both gross negligence and the THE proximate cause as a two-step process to avoid, get around governmental immunity. Have you?
No, I think that's correct.
I think we're the only state, but if we're not, we're one of a couple. Why is that so important? And it's so hyper-technical, and this is what they wanted to do, folks. This is why they passed it when they did it and how they did it, because they didn't think you all would be paying attention and know. When they actually passed the law, they used the word "a" proximate cause versus "the" proximate cause. Meaningless to 99.99% of people. And under Michigan law, it was meaningless from the time it was put into place in 1986 until the year 2000, when all of a sudden it changed. We had an opinion in 1996, I believe, DEDES, D-E-D-E-S, that actually said, hey, there's rumblings out there in the law that some of you think there's a difference between a proximate cause, and the proximate cause. We, the Michigan Supreme Court, went back and looked, and no one it's called a legislative history. They keep notes, so they know what people were talking about before they actually passed a law and why. No one talked about a distinction or a difference between and the. Not one person. So the Michigan Supreme Court in DEDES, D-E-D-E-S, said and the means the same thing. It's no different. And remember, a proximate cause is what we use in every other civil case, unless there's a government involved. So then came the year 2000, I'll call it the Engler Court, and now we had Governor Engler and his folks that were now in the Michigan Supreme Court, and in Robinson versus City of Detroit, they flipped the law completely over 180 degrees and went back the other way and said, oh, no, 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 the proximate cause means the most immediate, it means the last, it's got to be like the most certain, the most one. And we knew it was bad for us back then. I was obviously in practice for about 13, 14 years at the time, but nobody, and I mean nobody, anticipated how far they would take this definition. So what then happened, ladies and gentlemen, from 2000 until the Ray decision.
2017.
In 2017, in Ray versus Swagger, case that Chris Desmond and I argued before the Michigan Supreme Court, it was the first time since 1992, 92 to 17, so 8, right? 18.
96
So,
in day days.
okay. So first time that they ruled in a plaintiff's favor in nearly 20-some years. And in Swagger, Ray versus Swagger, they held that no, the proximate cause doesn't have to be the last. It means the most immediate, and that's up to a jury to decide. Not a judge. It's up to a jury to decide what is the most immediate, and they look at all the conduct of various people. So that's what we were arguing in front of Judge Brennan. All of these things, and ultimately, as I'll show you, she ruled that the only person that could be the proximate cause here is Crumley, Ethan Crumley, which we respectfully disagree with, and we believe at the very least, the whole law should be thrown out, but at the very least, we should have a jury question. In other words, we should go to trial and let the jury decide this as opposed to her. I'm going to skip over going through the opinion, all right? If any of you have specific questions about it, I know that's probably too much in the weeds. I'm going to let you ask us that individually, but I think you get the point now. So what I'd like to do now is turn it over to the most important people in this room, no offense to anybody else, but our clients. And I want you to hear from them. And normally, I let the ladies go first, but Mr. Myre, Buck, and Sherri, I'm going to let you folks go first, please.
Thanks, Ben. I hope everybody plays that 5-minute explanation by Ven over and over and over again, and understand this. It's unfair. It's unconstitutional. It doesn't look out for we the people. So you got this whole law and all this craziness, and then you get a judge who is what? A government employee that gets to bless us whether we go to trial or not. How can you beat that? So, is this decision a win? I would say for our authoritarian, overreaching government, that's a yes. For we the people, that's a no. So to this date, we've had nothing done. We have no investigation, no explanation, no accountability, nothing. Educate yourselves, and you're about to learn why. I want to tell you a quick little story. Back in 2019, I was helping our AD, then AD, set up for a football game. As we're walking around the stadium, the concrete's all heaved. So I pulled him over and I said, hey, this is a safety hazard. You need to have maintenance get all over this. He said, I've told him, Buck. I don't know. I've told him more than once. It's their call. So I kind of walked away thinking, man, I'm from the privatized manufacturing world, and we see a safety hazard, we put it to bed. Today. Not tomorrow, today.
To prevent injuries.
To prevent injuries, okay? So I walked away kind of scratching my head. I didn't get it. So here we are, 5 years later. Now I get it. They don't have to repair that. They don't have to make it a safe place for people to go walk, because they got this umbrella law that protects them from maintaining their facilities, for operating their business with best practices. They don't have to be great. They're the government. They got this law, governmental immunity, that protects them from being great, unlike private businesses. And this is their defense. This is their defense. We did not maintain that sidewalk because we knew somebody would get killed. That's their defense. But my argument would be, they didn't maintain the sidewalk and create a safe place. That's negligent. If somebody trips, gets injured, or dies, that's grossly negligent, because you're making decisions running your business that isn't creating a safe environment. This is their defense. It's horrible. So let's make a comparison to November 30th. And by the way, this has not been reviewed by Ven. I'm not a puppet. This is my thoughts, our thoughts. So let's make a comparison to what happened on November 30th with that scenario I just told you. There's a shooting that takes place at a public school. 4 children are murdered, 7 others shot, hundreds of other students are terrorized. The school did not have threat assessment policy in place or a team assembled threat assessment. They didn't have any protocols in place to handle the situation and to make it a safe environment. And here is their defense. The shooter brought the gun to school and is the immediate cause for death. There was no other reason for any deaths, anything that happened that day. There's no other reason. While we can all agree, he is obviously one of the reasons. We can all agree on that. Can we talk about and investigate the failures of the school before and on that day and make a good argument that the school is the immediate cause of death? You see, he came to school with a gun in his backpack. He was flagged. He was ushered around from person to person, and nobody knew how to deal with it. So off he goes. Then he starts his shooting rampage. He didn't walk into the school with guns ablazing. He walked out of the counseling office with guns ablazing. Who's the immediate cause? I think you could make an argument that the school is the immediate cause. But we can't make that argument because our government doesn't want to be tested. They don't want to be questioned. They're allowed to do that to us, but we're not allowed to do that to them. Unfair, double standard. And lastly, you know, Ven hit on it a little bit and I interjected here. Governmental immunity is the school's only defense. They have nothing else. They have nothing else. So what they've done, very, very smart, very strategic, okay? They've silenced all their employees. All their puppets have been trained very well in their depositions. They're all the same. They're all puppets. The school board is silencing our community, taking time to talk from 5 minutes down to 3 minutes. Here's their strategy. Everybody stay quiet. Don't say a word. We can't let this get to the point where we are questioned and investigated. You know why? Game over. That's why. So they hide behind this umbrella law, and we can't even question a damn thing. That's unconstitutional, that's unfair, and that's a double standard. So I encourage everybody, all my fellow Michiganders. Well, actually, let me back up one quick second here. I want to ask all these school employees a question here. What are you scared of? What are you protecting? This may be your only opportunity in your lifetime to drive change that needs to happen. And you're taking advice from people that are about money and power, not about us people. So think about that, school employees. Speak up. Be the change. Don't be a puppet to the money and the power. For all my fellow Michiganders, write a letter to Governor Winter, Attorney General Dana Nessel, your state House of Representative, and your state senator, and talk about how unconstitutional and unfair this law is and how it's a double standard. Our government is not above the law. Thank you.
Thank you, Buck. Sherri, anything to add?
No.
Pick up on 2 quick points. Number 1, if this happened at a private school, none of these defenses would be allowed. The same rules that apply in every other civil lawsuit would apply. Negligence, a proximate cause. Different when you have government. Last quick example from me. Uvalde. We were all so offended by Uvalde that the actual governor of the state of Texas and the chief law enforcement officer, neither one of whom I'm very aligned with politically, they did the right thing and got on TV and publicly spoke and said, these officers waiting over an hour, they messed up. Under this interpretation of Michigan law, our lawsuit, if there was a Uvalde here, and there was none, Oakland County Sheriff Department were in 9 minutes. But if Uvalde happened here in Michigan, this case would hold that the most immediate proximate cause was Ethan Crumley, and therefore you wouldn't be able to sue any one of those officers who waited over an hour. That's the evil doings of governmental immunity. Let's talk now, Jill Soave, mother of Justin Schilling. Jill?
Thank you, Ben.
Thank you.
When it comes to governmental immunity, people need to stand up with us and be outraged. Especially if you're a parent and who have children in public school. When I moved to Oxford years ago, and I moved for the school district itself because of its world-class education. That's a term they like to throw in all the emails. And believe me, they did give the community and a lot of children a world-class education of how the world kind of really works, sadly. But when I signed my kids up to go to school, I had no idea what governmental immunity was. I had no idea that I was essentially signing their rights and their safety away. And eventually, Justin's life. I had no idea. When we did get the news about the ruling, you know, obviously we were heartbroken and devastated, really in shock. And this doesn't just affect me, this affects the whole community. I've had so many people reach out to me, and they don't how could this be true? How could the security guard that opened the door and didn't clear the room and could have saved Justin and could have spared Keegan's trauma, how can that individual have no repercussions? So people do need to educate themselves, they need to stand up with us. This is wrong, it needs to be reversed. I know in the weeks leading up to the shooting, there were many parents, I only know this now, that called the school. Because a lot of kids knew, they said the school's gonna get shot up, I don't wanna go to school. I wasn't in that loop of those parents. But they called the school and they were told, from one firsthand account from a father of my child's friend, they were told, there's no real threats, nothing to worry about. Did those parents know what could happen and governmental immunity and how this could affect their children? So, you know, here we are, 15 months later, and we still don't have full disclosure on the events leading up to my son's murder. What message are we sending to the community? We have a community of kids in Oxford who are severely traumatized. They're not okay. We have an extended group of family and friends that lost 4. We have several injured. And what message are we sending to them? In my opinion, we're saying your lives don't matter. You're not protected. This is fundamentally wrong. You know, I look at all children as a mom. I love nothing more than children. We have to do the right thing. We have to fight and not give up, and thank you, Ven and the team, because this needs to change. Not just for my family, my children, Justin's extensive coworkers and teammates and people that he meant everything to, for all of the children in Michigan. Let's just start there. Who's more important? Nobody.
Thank you, Jill. This is a prepared statement from Justin Schilling's dad, Craig Schilling. Good morning, ladies and gentlemen of the press. As of the start of this press conference, it has been 462 days, 20 hours, and approximately 58 minutes since I last heard from my son. There were a few moments before he was brutally and unnecessarily assassinated that he was able to text, "I love you, Dad." A phrase he had said countless times before. Only difference this time is that he wouldn't be there to hear me say, "I love you too, son." For months after that day, I sat in darkness through sleepless nights and rivers of tears, waiting for someone to come forth with some information as to what in the hell actually happened and how could it have happened, but I received nothing. It wasn't until a meeting with the prosecutor that I realized that it could be a very long time before I got any answers, if even at all. Now, having never gone through something like this and having very limited knowledge of the inner workings and procedures of the judicial system, and having so many unanswered questions, I knew the only choice was to hire someone who was willing and experienced enough to ask these questions for me. This led me to Ven. Thank you, Craig. I had never heard the name Ven Johnson until he introduced himself at our first meeting. I had also never heard of the term governmental immunity. This term, I was assured, was the biggest obstacle to clear in any case involving a government employee. He then went on to explain that it was a law put into place that protected government employees from being held accountable for their actions or lack thereof in the event that they're named in a lawsuit. Being a reasonable man, I understand the need for laws. Without them, life as we know it would be very different. But I do not understand why there are laws that protect some people and not others. How is that fair? Don't we all live in the same society? Didn't our forefathers establish a constitution that governed us all equally under the same laws? Why did this change? How can we have different standards for different members of society based on whether they're employed by the government or a private entity? That just seems ridiculous. I believe that an individual who is educated and trained for their chosen career, whatever it may be, and whoever their employer is, would perform their duties with more diligence and care than an individual who took their position knowing that there were no repercussions for their actions or inactions, as the case may be. As an electrician, I don't do my job correctly. Do it again. As an electrician, if I don't do my job correctly, someone could be killed. If I was found to be if it was found that my work was negligent and the cause of someone being electrocuted, I would be held accountable, and depending on what type of trial I was in, I would be punished accordingly. It's my understanding, with my limited knowledge of the judicial system, that the determination of accountability is made by a panel of my peers called a jury. The jury is presented with all the evidence submitted and approved by the court. The lawyers are there to make sure that the jury understands the significance or insignificance of that evidence. When all has been presented and understood, the jury has to make a unanimous decision. What I've recently learned was that in cases where government employees are involved, a lawsuit can be thrown out of court based solely upon governmental immunity, without even having all the evidence presented to a jury for their unbiased consideration. Now, based on the sheer magnitude of this case and the fact that there are so many people affected by this tragedy, I do not envy the person who had to make this difficult ruling, nor do I feel that one person should have to bear the burden of this decision. Although heartbroken by this ruling, I understand that it has been made without prejudice and in accordance with the law. Unfortunately for us, the law is stacked heavily in favor of government employees. I feel that this is not only unfair, but also unconstitutional. There have been many hours put into the discovery of what actually happened. I ask that those, if named in this lawsuit, truly feel that they did their jobs to the best of their ability. Why do you hide behind governmental immunity? I feel that they should be able to stand tall and proud and with complete affirmation that they did what they were supposed to do in front of a jury, and let the jury decide, just like what they would do if it were someone else, anyone else. Give the community a chance to hear everything that happened. Let a jury decide the outcome. Give the families that have lost so much some type of closure instead of heartbreak after heartbreak. Thank you for your time this morning. Sincerely, Craig Schilling. Meghan Gregory.
Hearing the decision Friday for us, my heart sank. I think the biggest blow is knowing now that these employees are able to hide every truth and bury the lies as deep as they can. The community is at a point where we need to know the truth. We're dividing further and further apart. When you aren't held accountable, why care? How can change ever happen if we are never held accountable? This law was done to protect the king. Considering we live in a country that prides ourselves on freedom, I'm not sure why this law is in place. I do understand if a firefighter were to go into a building and carry someone out and breaks their pelvis, okay, let's protect them. I can be totally fine with that. I cannot be fine with the fact that 4 kids were murdered in our school and not one person will be held accountable. The sad reality is no one will ever heal. These 4 families have no explanation on why their children did not come home that day. We have a traumatized community trying to understand how these people are still employed by the school and walk around as if nothing ever happened. A district that just informed us last week, or 2 weeks ago, that our children's lifetime earnings will be significantly decreased because of the mistakes made that day. So I do hope that people remember we do live in a small town. People talk too much. The truth will surface. Policies are put in place for a reason. Hopkins chose to follow policy during the Alice lockdown. He hid under the desk very quickly, protected himself, but chose not to follow procedure when Crumbly was in the office that day. Explain that one. So while I can understand laws need to be there, we've now made a choice to change our victims law because we can recognize that mental trauma and its effects on people. It's time Michigan moves forward and looks at the laws from years ago that really should not have anything to do with what they're in place for. It's a silly law at this point.
Thank you, Megan. Chris Desmond, want to address the appellate aspects?
Very quickly, to move from the very emotional and moving statements that we just had to explain to the media what this appellate process is going to look like. We'll be initiating our appeal in the coming weeks in the Michigan Court of Appeals. That will start what will likely be a 12 to 16-month process in the Michigan Court of Appeals. So during that time, for those who aren't familiar, the majority of the work done in the Court of Appeals is done through writing. So both sides will be submitting a brief where they analyze Judge Brennan's decision and whether or not it was correct under the law. We will then, at the point that we write those briefs, we have no idea who our judges are going to be or when we will be presenting our argument to the Michigan Court of Appeals. We'll find that information out in roughly 10 to 12 months, I would assume. We'll obviously keep the media updated on all of those developments as they come in, but ultimately we'll be given a hearing date in front of 3 randomly chosen judges from the Michigan Court of Appeals. That argument will take 30 minutes to an hour and will occur in either Grand Rapids, Detroit, or Lansing. We'll then wait for a decision from the Michigan Court of Appeals. Because of the gravity of the issues that are involved in this case and the nature of governmental immunity in general, in our experience, whoever does not prevail in that argument in the Michigan Court of Appeals will very likely take this case to the Michigan Supreme Court. That process can take anywhere from another 6 months to a year and a half. And so we're looking at a long road ahead in the appellate court, where these families, of course, are going to have to deal with the pain that they just explained to you so clearly that governmental immunity has inflicted upon them, following the trauma that was inflicted upon them by Ethan Crumley and the various negligent and grossly negligent actors here. While we're on appeal, none of the arguments that are going to be made are going to be surprising to the members of the media who are here today. I know you've been following this case and our arguments from the beginning. We'll be arguing essentially twofold. We'll be arguing, first of all, that under the current state of the law that Judge Brennan erred, and that this is a case that can proceed to the jury even under the harsh limitations of governmental immunity. But in addition to that, we'll also, of course, be arguing that governmental immunity, especially as it was applied in this case, is unconstitutional. As Ven has stated throughout this case, this is a situation where if this occurred in a private school, God forbid, none of the defenses that have been discussed and developed during this case would be at issue. Those families would have an ability to get a remedy in this case, frankly, probably at this stage would have already been decided by a jury or presented at trial. Because of governmental immunity, if the members of the media who are here today examine the Michigan Constitution, I believe it's the second sentence of the Michigan Constitution, says that no individual shall be denied the equal protection of the law. And it's very difficult to imagine how you can tell these families today that they've been given the equal protection of the law, that their children were given the equal protection of the law, when they were just explicitly told in this decision that because they attended a public school instead of a private school, this is the way that the law applies to them. So we look forward to our opportunity to be able to present that argument in the Michigan Court of Appeals, as we've done, frankly, from the moment that I joined Ven. This is an issue that the media is now seeing, but this is something that we deal with all the time. On a daily basis, we're dealing with governmental immunity at the state and federal levels. There are families after families after families that the media hasn't seen who have been victimized by these laws as well. So we're hoping that we can make a significant impact and change on that law so that other families in the future don't have to go through these same tragedies.
Thank you, Chris. Before we take questions, one of the greatest things about civil law, and one of the reasons why I've done it for 37 years, is because of the opportunity to effectuate change for the good. Criminal law usually happens immediately after an incident. Folks are arrested or charged. They ultimately go to trial, typically within a year. And the investigation, although thorough, oftentimes does not branch out into every single person who could arguably be held accountable. That's where the civil law comes in. We, in the private end, since civil law is private, we have the time, the money, and resources to dig and investigate all sorts of things. Everything from a horrible shooting in Oxford Community School District, Oxford High School, to a train derailment in Ohio, to a shooting in Uvalde. I could give you example after example. We dig, and with that, we dig and get to take depositions and do what we call discovery to learn, to get to the bottom of what happened. Therefore, you get to expose the good and bad. The defense certainly gets to say, make their arguments, just like our clients have said. Stand up. If you think you did nothing wrong, then face the music and say that you did nothing wrong and let the jury decide. And then ultimately, out of that, we learn from our mistakes. And oftentimes, in civil litigation, one of the greatest things that I can ever give a client is really me not giving them a whole lot, other than standing up with them and watching the change that happens because of folks who were strong enough to stand up and say, this is wrong. That's what we feel about these people right now. They are standing up to an entire government, an entire system of laws that have been wrong for so long. And I thank them and I commend them, and it is absolutely our honor to sit up here and fight with them. Justin, let's do questions, please.
Ben, do you anticipate this is going to the state Supreme Court regardless of the outcome in the appeals court? And I assume they would appeal if you were successful. And isn't this going to end up in the Supreme Court anyway? And wouldn't that be the best place to effectuate change you're talking about?
Answer is yes. That's where I think we know that this is going to go, Gino. But the fact of the matter is, I can't skip over the Court of Appeals. They don't say, Ven, if you want to, just skip over them and go right to the folks you need to go to. Doesn't work that way. So I have to work within the confines of the legal system. We do. And so we will obviously appeal to the Michigan Court of Appeals first. They will make their ruling, and then we will address what to do next. And I'm guessing either side that loses will likely ask the Supreme Court to look at the case. But understand the difference. In this particular case, more sooner than later, Court of Appeals will have to hear this case. Supreme Court doesn't. So they can choose to look at it or not. So it's different levels and different things going on at each level. So it is a kind of a complex answer, but I hope I answered your question directly.
This question is for the parents, and Ven, if you want to chime in too, obviously that's fine. Over the last 15 months, we've heard a lot about calls for accountability. Given the ruling, what does accountability look like now for you guys?
Ladies first.
For me, accountability would be a jury trial. Just showing, if they choose to make a decision that, okay, they did nothing wrong, I can move forward. But the fact that there's so much evidence out there, it's really scary that they're still employed at this point.
let me jump in and I want you folks to answer. That is one of the inherent catastrophes of governmental immunity, is that so many of these cases get thrown out of court before your right to a jury trial, so that the folks feel, and understandably so, that they're victimized all over again. But please, Jill?
Yes, no, I mean, I don't know what I could add to that. You summed it up. I'd agree with Megan. We need all the facts out. We need to know the complete truth. We need everybody who, you know, was involved before, the weeks before, the few days before, the day of. We need everybody to be held accountable. And we're not going to get change until that happens. We're not going to get any sort of peace to move forward. And I don't care how long it takes. I'm going to keep fighting for Justin, because his life mattered, and this is wrong.
Sherri, Buck?
Yeah, boy, this is a rabbit hole I could go down and we could talk about all day, but, you know, for me, there obviously needs to be some pretty big changes that happen in our schools. Quit acting like something didn't go wrong that day, right? So, to me, change comes from driving accountability. And for everybody to think that nothing went wrong that day, 4 kids were murdered, 7 others were shot, hundreds of kids were terrorized. So accountability would be, let's roll the balls out, and let's find out what went wrong that day, and let's learn from it, and make it a safer place for future kids.
Sure. It's so important to remember, in a situation like this, what we believe is the case should go to a jury. It does not guarantee us a victory, and I need John and JQ Public to get that, because that's where they think it is like, you just want to win. Of course I want to win. That's what I do. But I want to win in front of a jury. What I don't want is a law that basically has one person, one judge ruling that it doesn't go to a jury, and then there'd be no recourse. My clients want their right to a jury trial. Did we answer your question? Thank you, ma'am.
Question from Matt Farr with the Oakland Press. How do the parents feel about Oxford staff named in the lawsuit still being employed by the district?
It's disgusting. It's about as much as I can say about it.
Absolutely. It doesn't make any logical sense. You know, if I can put myself in their shoes, and I can have empathy for everybody, absolutely. But if I was involved in any capacity, I would have just immediately resigned. Because what does it say to the kids who are still there, who were there that day, and they're seeing these people, and it's got to create more trauma for them. And almost like a way to disassociate, like, well, I don't understand. I'm hearing these things on the news that these people could have stopped this, and they didn't, but I'm still seeing them in school. I don't think it's good for the children, and I think, again, I would have just resigned and at least out of respect, you know, lessen the pain for everybody moving forward.
Yeah, that's a strategic move by their attorney, because if they suspend them or put them on a leave of absence, that shows that they're guilty. So it's a strategic move. Yeah, good for them, you know. I mean, at the end of the day, I think, are they guilty? I don't know. Let's roll the balls out and play. Let's find out. You know?
Question from Trevier Gonzalez, WZZM, I believe for Chris Desmond. Is the main argument to be made during the appeal process that Judge Brennan's decision violates the state constitution?
I wouldn't say that that's the main argument to be made. That's certainly one of the arguments to be made. But an additional argument that's going to be made, you know, Ven has referenced, there was a case in 2017 that our office handled called Ray versus Swager. In that case, The Supreme Court laid out a very specific type of analysis that applies when you are determining whether or not a governmental employee was grossly negligent and, as Ven has been saying, the proximate cause of an injury. We don't believe that that analysis, that framework was followed properly in this instance, and that if it was, there would be a different outcome. So we'll be making an argument that even with Governmental Tort Liability Act in place, we still should have prevailed in this motion, and this matter should have proceeded to a jury trial. But alternatively, we'll also absolutely be arguing that the Governmental Tort Liability Act is unconstitutional, that it violated our clients' rights to both equal protection and their right to a jury trial. Those are both constitutional rights that all individuals in Michigan have, and that our clients were denied in this instance.
Question for Ven, Jonathan Yinger, CBS Flint. I understand that, like Oxford, many school districts in Michigan require teachers to only notify leadership of troubled students rather than reporting. These teachers fear the loss of their jobs. Do you know who within Oxford set this policy that's contrary to what should happen? In this case, should all involved be liable, or just the leadership that required teachers to report such things as up the chain?
My brother from Flint asking the great question about the Child Protection Act. Phenomenal question, and the answer is, under the Child Protection Act, everyone who violates that policy is actually criminally and or civilly liable. So yes, they should be held accountable. Arguably, they could be charged criminally. That's not my job. But what we did in this case, and what Judge Brennan did at the end of the opinion, is said there was no violation under the Child Protection Act. And sorry, let me tell you a little bit why she said that. There is a 2013 case called Jones versus Bittner, B-I-T-N-E-R, for those legal folks out there, 300 Mishap 65. That case held that even though the Child Protection Act clearly involves government actors, it uses the word teacher, it uses the word school counselor, it uses school principal, that's actually a phrase, not a word, sorry. But clearly, that could be private, that could be public. Those are mandatory reporters. So when our legislature passed that law in 2013, the goal was to protect who? The children. So that folks who did not report child abuse, child neglect, and what's part of child abuse and child neglect? Failing to get somebody who is having a mental health crisis that Ethan Crumley was so clearly having and had been going through for weeks, that they were witnesses to. Failing to report that should be, under the Child Protection Act, a negligent standard, approximate cause. The Jones case said, no, even though the Child Protection Act is a separate act, you still have to apply gross negligence and the approximate cause if you use that act against a governmental employee. That is so blatantly wrong. Chris Desmond could address that much better than me, but from a constitutional perspective of one group of laws to another, it offends every major constitutional argument I can think of.
Yeah, just to add to what Ven said, there was a decision in 2013 which said that if you sue under the Child Protection Law, even though the Child Protection Law, the actual phraseology in the law is that an individual who violates this act shall be liable.
Shall,
under the law.
must.
Shall be liable. It doesn't make any reference to, but if you're a governmental actor, you are not liable unless blah, blah, blah. It doesn't say that. In 2013, the Michigan Court of Appeals, in a published decision, which means it controls every court in this state, said that, well, if you're suing a member of the government, you have to be able to show that the government was the proximate cause, the governmental actor was the proximate cause. Well, child protection law cases are always premised on the fact that there is a child that is typically being abused or neglected by somebody else. So what the court explained in Jones versus Bittner is that you're never going to have a governmental actor who's the proximate cause of an injury in that case, because the proximate cause is going to be whoever was abusing or neglecting that child. So in this instance, for example, it could be Ethan Crumley's parents who were neglecting him, not the school officials who were aware of that neglect and failed to do anything. Again, if we were in a private school, that analysis is completely flipped on its head. These school employees could all be held liable for a violation under the Child Protection Law.
And I will tell you from a statutory interpretation, sorry to get the weeds real quick, meaning when you're looking at one group of laws versus another. Think about in 2013, the Government Tort Liability Act had been its current state since 1986. Translation, the legislature knew when they passed the Child Protection Law, which I've forgotten the year. They knew about the Government Tort Liability Act, and if they wanted to put gross negligence and the approximate cause into it, they could. Or what they could have said in the Child Protection Laws, we're just going to protect children in private schools. And again, if we haven't made that clear, then please make sure you listen this time. This is about the safety of the kids. These people lost the ultimate thing in their lives, their kids. And now they're standing up to the big bully, big government, governments who passes laws to take care of its head, and say, for the safety of kids, you can't interpret these laws like this anymore. They need to be thrown out. Because who's going to pay the price? Our school children, but especially our public school children. And as somebody raised by 2 public school teachers, God forbid, my dad would roll over his grave, and my mom down in Georgia would absolutely flip upside down. They would do anything for their students. Much like Buck said, stand up. My parents would be right here with us and say, you're not picking on us. You're trying to make us better. You're trying to show us the mistakes that were made to be better and safer. Next question.
To the parents, as a father to a teenage son, I feel for all of you, and I can't imagine what you're going through. Where do you gain your strength on a day-to-day basis to endure this battle?
My faith in God and prayer, morning, noon, and night. Trying to connect with Justin, to keep a little dream journal. I get very excited every time he pops in my dreams. But faith in God and prayer, and faith in humanity and righteousness. You know, we are going to get through this. We are going to make change. So that's for me.
Megan?
For mine is a little different. As you know, Keegan is still with us. While we grieve the child he is still here, and that's what gives me and Chad the power to keep pushing forward, because he doesn't function like every other 16-year-old boy. And we want to eventually see some healing start to happen with him. So that's what pushes us forward to keep trying to get this change to happen, so this doesn't happen to anyone else.
Sherri, Buck?
It's a great question. Sherri, you want to chime in first?
No, go ahead.
Yeah, that's a great question. I was just talking about this the other day. I did a lot of coaching in my day, and I wasn't a big X's and O's guy. I was big on the kids embracing in relationships with their peers, and I used to always say, be a junkyard dog. Things won't always go your way. That's life. You get kicked in the teeth every day. And that was always my message in coaching, just perseverance. So, and that was the message always at home that Sherri and I shared with the boys, was just keep grinding, man, because things don't go your way. So, where do I get the strength? I feel like if I didn't show the strength and didn't fight, I'm a liar. I lied to every kid I ever coached. I lied to my kids. They're watching my every move. They're watching our every move. How do we respond to this? Well, I'm going to respond to this how we've taught our kids and what I've always coached the boys up on. I'm going to fight, man. I'm a junkyard dog. I'm not going away. We're not going away. We're not going away.
Sure.
Obviously, every day is still hard to get through. Friends and family are always there. My number one is Buck, getting me through every day. But I think just striving for change and what we're doing with our 42 Strong mentorship program, it keeps me going every day.
Question for Ven from WWJ. Is the district willing to talk about some type of settlement? And if so, in your eyes, what would that look like? Continued thoughts and prayers to the family.
Well, I'm sorry that I'm laughing. I don't mean to be disrespectful. If the district were interested in doing the right thing, they would have stepped up on November 30, end of school day, maybe the December 1. No, they won. So what we see is what I believe to be a crooked law that they're taking advantage of. And to be fair to the district, if I were their lawyer, I would certainly do everything I could to protect their interests. So I'm not trying to dog anybody, but it shows the inherent inequity of the law. So will they step up and settle? No, they just won. They got nobody left in the case. So they're going to go up and appeal and understand now what's going to happen. You're going to have the major lobbying groups, right, come into these things. You're going to see the defense trial lawyers. You're going to see the plaintiff trial lawyers on the opposite side. You're going to see teachers union. Buck already talked about. You're going to see all the powers that be come into their respective sides, and hopefully they're going to ask to be a part of our appeal. You know they will. And so this is going to be a very, very big deal politically. And the last thing that we need, this law passed, folks, because it was political at the time. I don't think it would pass today. I don't think it would. I think most of us agree that government should be held accountable to us because they work for us, and everybody should be equal no matter what. But in any event, it passed when it passed because it was political. And now I think that the courts, one of the great things about our court system that we have faith in, that's why we're still here and fighting, just like our clients so eloquently stated, we believe that ultimately the court system is going to get it right, that justice will prevail, and that we're going to choose safety of all kids, not just private school kids, that all kids should be safe when they go to school.
Another question from Matt Farr, Oakland Press. How does this decision affect the federal case with a majority of defendants named and other Oxford employees that is before Judge Goldsmith?
Matt, I'm going to tell you what I told you last Friday when you asked me that, but another great question, very insightful. Our federal lawsuit did not have state law claims. So that is going to be something that Judge Goldsmith and the folks in the federal court are going to be facing. And because we had all of our Michigan state law claims in Oakland County, that judge, to be fair, just threw out as it relates to the school district. Whatever happens across the street in the federal courthouse as it relates to state law claims does not impact our case. You should talk to the other lawyers on the plaintiffs on what could happen there, and I'll let them address that. Since I don't have those claims, I think I should let them speak for themselves.
Question for the parents from Hannah Mackey with the Detroit News. Since there is a hearing happening this morning to determine whether or not Ethan Crumbley's parents will stand trial, do you want to see them face charges?
Hell yeah. They bought a gun for their kid, right? And he used it, murdered our kids, man. Yeah, absolutely. I don't care if there's not a law out there or not. Like, it's crazy. Think about this. There's all this going on and all this legal talk. 4 kids were murdered. And everybody gets to throw their hands up in the air. How effed up is that? Seriously. How freaking crazy is that? It's amazing to me. Everybody just gets to throw their hands up in the air. It's not my problem. It's crazy.
I absolutely do. I think they're one of 3 that need to be held accountable. So, yeah, absolutely.
Right, of course. I mean, they should get the max, they should be held accountable. Everybody involved will be held accountable, as they should be. It's not just one person who contributed to this. Many people, so absolutely, yes.
Another question from Matt Farr for Ven. Is it true that an offer of mediation was turned down in favor of going forward with a lawsuit, and that there was no offer heard from Oxford schools on a possible settlement?
Not that I know of, Matt, but the answer is that would be something that occurred in the federal court, and since I didn't have state law claims pending in that court, I have no comment.
Last call for questions. Any last statements, Ven?
Thank you, everybody, for being here. On behalf of our clients, if there's one thing that you know today, we have the resolve. We will continue to fight every single day for our clients and hopefully achieve justice, not just for them and their case, but for their kids and everybody's kids. Let's have everyone's child be safe no matter what school they go to. Thank you very much.